So these are a few introductory notes on fixation and originality. To understand Cartoon Network, it's useful to do a quick review of the other major case on fixation, MAI versus Peak Computer from the Ninth Circuit. The plaintiff made computers and software, and that included the operating system. The defendants serviced computers, including the plaintiffs. It was often necessary for the technician to operate the computer and the operating system to service the machine. The software license allowed plaintiffs' customers to use the software for their own purposes, but not for use or copying by third parties. The court ruled that copying occurred when the computer program was transferred from ROM or another storage device to RAM, the random access memory. That is, when the computer was turned on. This was enough fixation to count as unauthorized copying because the RAM copy lasted long enough to be perceived and/or communicated. Side note, there's an exception in Section 117 for making or authorizing a copy for archival purposes or as an essential step in using a computer program. But this wasn't enough to protect the defendant because the users were licensees, not owners. Section 117 at the time only covered owners of copies. Many people found this a disturbing result because, of course, this didn't really affect any copyright interests. This just allowed the plaintiff to cover the aftermarket for servicing its products. That was anti-competitive. MAI was able to use copyright rather than other ways to protect its market, such as contracts with customers. So it got access to copyright's enhanced damages compared to the damages from breach of contract, and it avoided having to sue its customers for breach. After MAI, Congress amended 117, and you can take a look at subsection C and ask if it fixed the problem. The focus is now on someone who owns or leases a machine and on repair of the machine, not fixing software problems. It doesn't matter whether you rent or own the software for purposes of applying 117C. However, the larger point is that after MAI, it seemed that anything you display on your computer screen for long enough to perceive it would be fixed, even though that's inconsistent with the legislative history. And it's, of course, also possible that the legislature didn't understand how computer programs and RAM worked. So we'll talk more about that in class. The second topic of the day is originality. Section 102A requires an original work of authorship. One question to think about is whether the constitutional requirement that copyright protect writings of authors imposes any originality requirement. In other words, can you be an author without being original? We'll consider authorship in a bit, but for now we're going to look at originality since at the very least the statute requires it. Congress didn't want Section 102A to be precisely coextensive with the constitutional boundaries of its authority, but it didn't make clear what the difference was supposed to be, and in practice, the constitutional and statutory standards have converged. Likewise, originality is not expressly required by the Berne Convention or TRIPS, our international commitments, but some level of creativity is required. Different standards for originality are possible. It could be novelty, ingenuity, something more like the patent standard. It could be merit. Germany and Japan, among others, have toyed with this idea. China appears interested in requiring some level of artistic creation. On the other hand, originality could just be a distinguishable variation from what's gone before, or it could be independently created by the author. And there are two possible meanings for independent creation by the author. One could be effort. The author has put in work, or the author has added something that has a creative spark. And it's the creative spark concept that we use. So starting with Burrough-Giles. So the plaintiff had taken a picture of Oscar Wilde. The defendant had copied it for an ad for hats. And when we say taken a picture, we mean set it up. Cerny actually had a person hired to operate the camera physically. Cerny's explanation of what he had done emphasized staging. So he set up the background. He told Wilde how to present himself. He did not emphasize the technical choices like framing or lighting that he'd made in taking the picture. A key point, not obvious to us today, is that whether Congress could protect photographs was not free from constitutional difficulty. That is, there was a non-trivial argument that a photograph was not a writing and was not a product of an author. Instead, it was just a reproduction or representation of nature. However, the court reasoned from protection of maps and charts, which are grounded in long history since 1790, and those also purport to represent nature and are still copyrightable. The court reserved opinion on whether an ordinary photo could be copyrighted. But here, Sereny was responsible for positioning the subject in the background, so the picture owed its origin to him. We'll explore how copyright currently treats photography further in class. Now I'm going to introduce a couple of Copyright Office proceedings where the office ruled on what is and isn't sufficiently original for copyright. The office does not have final say, but courts often defer to its expertise. So here we have a reconstruction of a dinosaur that was not protectable as sculpture because it only features a few very basic elements in a simple and realistic combination. Most of them came from fossils found in nature with missing pieces replaced by casts based upon scientific interpretation of how the extinct dinosaur and its various bones may have appeared. The choices in creating the casts weren't the product of creative choices, but were dictated by the remainder of the skeleton, which was clearly created by nature and not by human authorship. Slightly differently, we have these Apple animations divided by whether the office deemed them copyrightable or not, and one question is whether you see the same distinctions that the review board did. We also have two minimal designs. There isn't enough here to get a copyright. Likewise, these are also too minimal. And this is too minimal of a design to get a copyright. But the standard applied by the Copyright Office remains low. So this gets a copyright. Both the logo and the entire configuration are creative enough to be copyrightable. So it's not a tininess limitation, although tininess matters. Likewise, the Copyright Office registered this. It is enough of a variation from a grid pattern that there's something creative there. In addition, courts may be more protective toward copyright claimants once they confront an actual copier. So in this example, it's not just the video that the court found at least potentially protectable, but the 2-second combination of dance moves within the video as choreography that might be enough to be protected and therefore infringed. So the Ninth Circuit said possibly enough there to protect against infringement. And that's it. I'll see you in class.